rather busy with Lebanon.
If I had an injury, in fact, then
In Salt Lake City as an area,
My problem is,
Good evening. I'm Hiram Chodash, Dean of the College of Law, and I'd like to welcome you to our 42nd Leary Lecture. Before I introduce our distinguished speaker tonight, I'd like to express both the humility and honor of our collective association with this lecture. In keeping with the rich traditions and exciting future of this dynamic law school, with this lecture we honor William Leary, the second Dean of the College of Law, an outstanding exemplar in a long line of great deans, including more recently the late Lee Teitelbaum and our dear colleague Scott Matheson. Scott, will you just stand and be recognized? We're so happy to have you back. Born in Massachusetts, William Leary received his A.B. degree in 1903 from Amherst. He graduated from the Chicago Law School in 1908 with a J.D. For those of you who've complained that I'm too young to be a dean, I want you to know that Dean Leary was appointed to the deanship in May of 1915 as a 34-year-old. He served for a remarkable 35 years and took the school through 2 world wars and the Depression, and also served as the heart of the school's teaching program. He was well known for his wit, intensity, and flair for the dramatic. He shifted from waxing as a philosopher on the role of law in mediating conflicts to impersonating Jack Dempsey to illustrate the principles of assault and battery. Beyond his classroom performances, his stated aspirations for the school are still instructive today. Though not a scholar himself, he once wrote that he'd like to, quote, see freer discussion of philosophical questions, a broader, more tolerant attitude, a deeper respect for others, a richer culture, and a truly intellectual atmosphere. This sensibility helped build the foundation for the fiercely independent and engaging intellectual environment we enjoy in the school today. The lecture established in Dean Leary's memory is now in its 42nd year, having attracted many of the leading intellects in both the judiciary, from Traynor to Brennan, and the academy, from Rostow, Falk, Minnow, our very own Fordham, Brest, Rose, Amar, Sunstein, Lessig, Coe, Fallon, and so many others. Given Dean Leary's great talent as a teacher and his philosophical and open intellectual values, we could not have a finer Leary lecturer here tonight. Pamela Samuelson, the Richard M. Sherman Distinguished Professor of Law and Director of the Berkeley Center for Law and Technology at the University of California at Berkeley. You've all read about her impressive background, her undergraduate and master's degrees at Hawaii and her JD at Yale, her teaching experience at Pittsburgh, Columbia, Cornell, Emory, Melbourne, Toronto, and Vrije, her publications. I count well over 115 law reviews, books, and book chapters. Her extraordinary MacArthur Fellowship and leadership roles at the Electronic Frontier Foundation and the Open Source Application Foundation. Her leadership in the Berkeley Center for Law and Technology and its impressive clinical program, which she founded, the Samuelson Law, Technology, and Public Policy Clinic. She's with us here tonight not only because of these special accomplishments, but also to share her pioneering insights on the complex public policy and legal controversies arising from the rapid growth of new information technology and the expanding role of intellectual property rights. Professor Samuelson offers a rare combination of theoretical acumen and real-world concern. Whether within the academy or industry, her work is considered central to intellectual property reform issues. As these issues are increasingly important to our daily lives, for example, the transformation of our economy from tangible to intangible assets, the challenging balance of economic incentives for innovation and public access to new technologies and forms of expression, the interaction, if not conflation, of intellectual property policy and the business models of our multinational corporate sector. Professor Samuelson's voice is central, is critical to our future, and we couldn't be more pleased to have the pleasure to listen to her thoughts here tonight. So please join me in a warm welcome for the 42nd Leary lecturer, Professor Pam Samuelson, and her lecture, Preliminary Thoughts on Copyright Reform.
Thank you for that gracious and warm introduction. I feel like I have a lot to look up to, or sort of earn here. I'm sorry, I'm a little intimidated by the introduction. But I'm really honored to be here, and thank you so much for the opportunity. It's wonderful to see some colleagues from law school here again, and very good to be in this beautiful city on this beautiful campus. And so I'm very pleased to be here, and thank you very much for coming tonight, because I know there are lots of other things that you can do with your time, and I will endeavor very much to make it worth your while. Copyright is all around us. We don't really notice it very much, but if you think about it, we interact with dozens of copyrighted works every single day. We read in morning newspapers, whether we read them online or whether we still read them in print. I still do a little bit of both myself. We listen to music as we commute. We watch TV or DVDs to keep ourselves entertained. We use web browsers and search engines to locate information resources all over the place. We use software to balance our checkbooks. We use databases to find legal materials. We make copies of articles that are relevant to our research, and we mark them up. And in fact, we are just in an information-rich, copyright-rich environment. We also create copyrighted materials daily. The papers that we write for classes or for other purposes, the emails that you send to your friends, the photos actually that you take with your digital cameras or phones, the tape recording that you might make of a talk that you need to give in order to get your elocution more polished. Maybe some of you also make remixes and mashups and post them on YouTube or places like that. You may not be thinking of yourselves as copyright owners, but because the law in the United States grants copyright protection to original works of authorship that have been fixed in a tangible medium of expression, copyright law is like attaching to everything that you create. And it lasts for not only your lifetime, but 70 years thereafter, whether you want it to or not. So you are more immersed in copyright than perhaps you thought about it. So as immersed, though, as we are in copyrighted materials, most of us really don't know very much about this law at all. We probably know that we're not supposed to go out and make lots of copies of DVDs and software and give them away to our friends and post them on the internet. I think we probably all can agree with that. We probably also know that, you know, if you find somebody's paper and you haven't asked them permission, you shouldn't put it up on the internet because it's just kind of not a nice thing to do. But social norms about interacting with copyrighted materials really haven't kept up with technical advances. And so some part of what I'm interested in talking with you about is sort of how we might get social norms closer to what a lot of people think the law is over the next decade or so. In some sense, we didn't used to need to know very much about copyright law because it was hard and expensive to make a lot of the copies that we could make of things, and a lot of the copies that we made in the analog world were kind of degraded copies, and if you made a photocopy of a photocopy of a photocopy, all of a sudden it doesn't show very well. Now it's not only cheap and easy to make copies, but to distribute those copies to everyone in the world potentially. And the copies, because they're digital, are perfect copies, identical to the original, and so the natural constraints on copying have sort of been removed, and so we need some copyright norms to get us through the day. And I think I can understand something about the way that at least a lot of, especially young people, think about copying music and the like. You know, when I was a youngster, we had long playing records, and we sometimes made tapes of those long playing records. For some of you, you take a CD, you load it onto your hard drive so that you can not have to carry around the CD all the time, and that seems really comfortable. So if you make time shift copies of TV programs and you rip CDs onto your hard drive, so what's the big deal about file sharing? Well, the scale and scope is a little bit different from the sort of private small-scale copying in the old analog world. I think it's hard not to know, after the MGM versus Grokster decision by the Supreme Court and 20,000 RIAA lawsuits against teenagers and others who've been engaged in file sharing, that file sharing of commercial sound recordings is just plain illegal. Some of you may still be doing it, or know someone who does. Not accusing anybody, but you still read data that suggests that more than 60 million people are doing this, and it makes sense that at least a few of them live here in Utah. And I think people try to, you know, say to themselves, if they think about this at all, gee, Eminem doesn't really need my money, he's already rich, or those RIAA companies, they're so greedy, and they're so mean, and I won't get caught, so no big deal. And it's true, you know, 20,000 lawsuits is like a lot of lawsuits, but if there's 60 million people doing this stuff, that's kind of a big gap. Now, I think that they haven't given up on these lawsuits, but it's really interesting that after all of those lawsuits, people are not stopping doing this, and that suggests to me that we've got a social norm problem that's not going to be easily solved, and these lawsuits are really not having the effect that I think the RIAA thought and hoped they might be. Many of us also enjoy creative remixes of movies. I love to watch things on YouTube, and I'm sure many of you do too. But have you ever asked yourself whether people are making fair uses when they put that stuff up on the internet? I think Professor Turanian's students probably do, but maybe the rest of us just say, oh, how cool, and don't think that copyright owners might want to say, gee, this is kind of tough. So what I want to suggest then is that digital technology has really changed the nature of our activities. We engage in more copying activity. Every access, every use of digital material actually involves the making of a copy. So all of a sudden, copyright has become relevant to our daily lives in ways that it really wasn't. And so at the same time, the sort of entertainment industry is saying, you know, we didn't like it when you used to make photocopies, okay? And we didn't like it when you made time shift copies. In fact, we think that all those copies are illegal. But you know what? It wasn't really causing a hemorrhage to our business until recently, and especially the recording industry has had a very substantial drop-off in its revenues, and yet many millions of copies of sound recordings are essentially being exchanged without any kind of compensation to the rights holders, and I actually understand why they're upset about that, why they see it as a grave threat. It's also understandable that in the face of that grave threat, what they want is stronger laws, put more of you in jail, sort of sue more of these people, get more damages from people who engage in file sharing. You may have seen that a young person went to jury trial in a file sharing case recently, and $220,000 was the penalty that was awarded to RIAA for downloading 24 songs. So this is kind of big money. Content industry also wants to wrap all of the content in technical locks so that we can't make copies. They want more control over more technologies. They want to make sure that DRM systems, digital rights management systems, get built into technology. They're trying to push for broadcast flags in next generation television sets. And they want more control over intermediaries. They've been working very hard to push Google to put filtering technologies in YouTube and other places. They're also working with ISPs to try to install filtering technologies at the telephone infrastructure level. So there's a lot going on that's being driven by the sort of the business concerns of these firms, and at the same time, we now have a stake. I think everyone in what copyright law looks like, and I think that the entertainment industry has a legitimate gripe here. But I also think that that they're using the sort of the piracy as a way to sort of cause imbalance to be injected into the law, where I think imbalance is still really important, and that's what I want to talk with you about. Now, digital technologies are not the only and certainly not the first technology to upset the apple cart for copyright. There have been a series of technologies that have been difficult. In the early 20th century, some companies made piano rolls. You know what a piano roll is, right? Those are the little things with little notches, and you put it in this machine, and then it kind of plays the music. Well, the initial piano roll people just made the piano rolls without trying to get permission from the copyright owners of the music. And so the music copyright owners sued them for copyright infringement. And the Supreme Court looked at the piano roll and said, "Doesn't look like a musical composition to me." So very soon thereafter, the music publishers went to Congress and said, we need a right to control the mechanical reproduction of our music in these new contraptions, and that's really the origins of the sound recording industry. There also was an early lawsuit once radio came along and people were playing music over radio, and a hotel got sued because it had a radio on in the lobby, and the copyright owners, the music said, "You owe me money to have the radio on," and they said, "What? This doesn't make any sense to me." In that case, actually, the court said, "Yeah, it's music. You're benefiting by it. Why shouldn't you pay for it?" Sometime later, however, there was another new technology, cable TV. And what cable TV was doing was basically picking up broadcast signals and then retransmitting them via cable. Very often those cable systems early on were going to places that broadcast TV wouldn't reach, right? So if you had a hilly area, there'd be like houses that wanted to watch TV and they couldn't get it, so cable TV was sort of supplying this part of the market. And so once again, the copyright owner said, "You are making money off our content. You must pay it." But the Supreme Court in two cases actually said they're not performing. And performing is when you go this is just passive retransmission of something that's essentially given away over the air for free. So how can this be a performance that infringes copyright? Eventually, the cable television industry did come to be regulated by copyright law too. So part of the story that we see is that sometimes new industries and new technologies came along. They disrupted things for a while. Then people said, we like this thing. And then deals got made inter-industry, and we got a chance to then have more things. I'm sure you all know that Universal City Studios in 1976 brought a lawsuit against Sony Corporation for introducing Betamax machines. This was the disruptive technology of its day, and horrors, these machines could be used to make time shift copies of programming, and actually some people made archival copies of the programs, including Disney and Universal movies. So they sued for contributory copyright infringement because Sony sold these machines knowing and in fact encouraging people to use them to copy their favorite television programs, and so that lawsuit lasted for almost a decade. And the Ninth Circuit Court of Appeals actually upheld the Universal's claim against Sony, and it was only by a 5-4 decision that the U.S. Supreme Court eventually reversed and said time shift copying of television programming is a fair use. At the time, that was the predominant use of the Betamax machine, and consequently, because there was a substantial non-infringing use of the technology, the Supreme Court decided that the Betamax machine could be sold and that copyright owners couldn't control it. Digital audio taping technologies was the next sort of disruptive technology to come along, and this time the recording industry went to Congress early, got a moratorium to stop digital audio taping machines from being distributed in the United States, and then eventually got legislation because these machines too, like the VCRs, were capable of substantial non-infringing uses, but the RIAA people argued that these would actually, these machines, if allowed to be sold, would ruin their business, and so they required that a technical protection measure be built into each of the machines so that you could only make a first-generation copy. If you tried to make a copy of a copy, it would degrade. And because the digital audio tape machines didn't allow you to make really good copies, that market basically disappeared. MP3 players were also challenged. What I'm trying to say here is that we've had a long history of some disruptive technologies. Somehow copyright survived them. And if some of us are wondering, can copyright survive the internet, I think at least some historical examples suggest that it could be, but there's a huge debate right now about whether or not we need stronger and stronger copyright rules because it's so easy and cheap to copy now, or whether we need copyright to lighten up a little bit. Let's make copyright do a certain amount of work, but then let other things, let people play with digital information. And so there's a raging debate about this. And maybe, in fact, the protection should be shorter. I told you it lasts for 70 years past your death. Well, you know, in the internet era, maybe we don't need a law that gives protection for such a long time. Maybe, you know, maybe 10 years, maybe 20 years, maybe a shorter period of protection might actually be adequate to be able to get enough compensation if you add value that you can recoup your investment and make you feel good for having made stuff available. So all this is kind of background to my thoughts about copyright reform. Why consider copyright reform? I have several answers to pose to that. One is that the current copyright law in the United States is the intellectual work product of a 1950s mindset. Okay, so they did a whole bunch of studies in the mid-1950s before computer technology came along, and they wrote a law that they thought was going to handle things, and they actually hoped that it was going to be an adaptable law and that they wouldn't, in fact, the committee that wrote and sort of oversaw this particular law kind of from its 1950s to its 1976 enactment. Once they passed the law, they disbanded the committee because they didn't think it will have to do any more work anymore. Well, the law has actually been amended at least 20 times since then, and it kind of, 10 pages more here, 10 pages more there, and it's kind of lost whatever coherence that it once had. But also, when the computer technology came along kind of in the mid-60s, the Register of Copyright said, oh, we don't want to put anything in the statute because it might be overbroad or it might be under-inclusive, we don't know what, so we're just going to pass the law and hope that it works out. And I think you can understand why some people in the other parts of the community who might be affected by this, like the electronics industry, said this is not a very satisfactory way of going about making law when you know that there's this new technology that's going to be likely to be disruptive. Passing a law without taking it into account is probably not a good idea. So that's a pretty important reason, I think, that we need to start thinking about it, is because we now have some experience with digital technologies, and I think we might be able to think about what the impact of that is and then try to get some balanced solution so that copyright owners get a chance to get their commercial exploitation, but we have some freedom to be able to use digital information pretty in a pretty open way. Okay. Second reason, the copyright law was written by copyright lawyers for copyright industries. Really, at the time that the law was passed and at the time the studies were done, it wasn't in contemplation that you and I and all of us were going to be interacting with information in this critical way that we are. So the law is written in a way that copyright lawyers, kind of what I call the high priests of copyright, can understand. But ordinary people, you read this law and you kind of what are they talking about? So I think that to the extent that the copyright law now reaches activities that all of us do every day, it's got to be a law that's more accessible to us, right? It's got to be something where an ordinary person could read the law and it would make some sense to them. They would get it. Okay, this is probably a norm that I should internalize. And we don't have a law right now that really allows you to do it. It's too long, it's too complicated, it's a hodgepodge. I can't even read it from beginning to end. It's more than 200 pages long. And there's also a huge gap right now between what the copyright industry lawyers think copyright law means and what most of you think it means, okay? I mean, I'm telling you, this gap is huge, okay? The biggest illustration of that gap is that most of the copyright industry lawyers think that making even one private copy of a copyrighted work is infringement. Okay, they really do. Even sort of loading the CD onto your hard drive or putting the songs on your iPod, they think that's infringing. Because they would like to sell you more copies of that stuff. And so that's what they think. Okay? Now I have a feeling that there are a few of you in the audience that think that all private copying is not copyright infringement, and that's probably not any more accurate than the sort of none of it is. Okay? Someplace in between, there is kind of a realm of private uses that I think probably we could talk about and sort of reach some agreement if we tried. But it's a big problem when the gap is this big because we want to have laws that people will really respect. And if 60 million plus people are file sharing on a daily basis, maybe we need to figure out a way to get some licensing system so that we get some compensation to the rights holders. I actually want them to get some compensation, but so that we don't end up throwing children into bankruptcy before they've had a chance to go to college. It's like, you know, Ms. Taylor is not going to be able to go to college now because she'll have to go into bankruptcy. Okay, so a few more things, and then I'll talk about some of the particulars. So there are an awful lot of challenging questions that are posed by advances in technology that copyright law, because it was written so long ago, just doesn't have a very good answer. It doesn't have good balancing principles, so you don't even kind of know exactly how to apply it. So courts are trying as hard as they can, but I think a model law or kind of copyright reform could help to address that. There are also some very serious political economy problems in the copyright policy-making arena. Hollywood is really, really good at lobbying. They're very good at telling a consistent story. They've built relationships with people in Congress over a long period of time, and when they come and say, we need more legislation, we need stronger rights, Congress on average is receptive to them, and so the concerns of sort of individuals like us don't have a way of sort of filtering up to Congress. And since most of us have not been very active politically about copyright, they don't know that we have alternate views, and I think also we need some reform because we've got to find a way to help copyright law adapt a little bit better without having to go either to very expensive litigation or very demanding sort of political economy problem making legislation. We've got to find some way to make it more adaptable. So these are the kind of challenges that have caused me to undertake this project to think about what copyright reform would look like. Let me give you just a couple of examples of the things that I'm sort of struggling with. As you may know, Google has decided to scan books, not only ones in the public domain, but also books in copyright from libraries from a number of institutions, including the University of Michigan, Berkeley, and Stanford. And what they're doing is scanning these books, and they are making indexes, right? The purpose of scanning is in order to make an index so that they can make available when people are searching for certain kinds of content, they can make available a little snippet, a short segment of the of material from some of these books, so that you can sort of see, oh yeah, that sounds relevant. So then you can follow up, and they'll make on certain pages they'll make available an opportunity to buy the book, or will tell you what library you could check that book out of. So they're not making the whole books available to the public, but some authors and some publishers have brought lawsuits to challenge this because they're copying whole books, and they're keeping copies of those whole books on their servers. They're also giving copies of the texts to the libraries whose books they are, and so that lawsuit is one that you look at the statute, it's really hard to say. It's certainly a reproduction of works in copies, which is what the law of copyright gives the copyright owner the right to do, but it's making the books more accessible. They're providing opportunities for people to see sort of things that might make them buy the book or check it out. And so in that way, it's sort of good for authors, right, to be able to get access. So you have a bunch of questions like that where, you know, Google's got this big target painted on its chest right now, and so some of these copyright owners would like some of that money, but the copyright law that we have doesn't give us very much guidance about how to do something, what to do with something like that. documentary filmmakers are also having a very difficult time because we've gotten to a point where many of the rights holders, including the recording industry and the motion picture industry and the television industry, where they just want you to clear rights and they want to charge a lot of money for rights clearances. And so sometimes documentary filmmakers actually have to falsify their documentary by extracting out something that was in the original because the TV was on when the documentary was made, and they can't get rights clearances for the clip that's in the TV set. So an example is it's a wonderful award-winning documentary called Sing Faster, and it's basically a film about the stage crew for the San Francisco Opera. So Das Rheingold is like up on the stage, and these guys are down playing poker, and and then they have to go up and kind of fix the sets and stuff like that. So the one really cool scene from this, as originally shot, had the Simpsons, because the guys were playing cards while they were like singing, this Wagner, and then they're telling each other like what the Wagner story is really about. So it's very, very fun. And so they're playing cards, and the Simpsons is on in the background, but they had to take it out because Fox wouldn't allow a clearance for that. And many examples of documentaries that were not able to be made or that had to be falsified in order for the filmmaker to be able to do something. This just seems wrong. So I think this is another example of things that you'd think would be good to be able to do, but we've got such a thick culture of rights clearances right now that it's really troubling for documentary filmmakers. I just was at a meeting recently with somebody from Boston TV studio. They actually, Boston's public TV station actually produces about a third of the shows that are made on the shown on public television. They're now thinking big, right? They want to put up all the programs that they ever made for public television on the internet so that we can interact with them, that we can download them, we can have access to them. Wouldn't that be fabulous? And they say, gee, this is, the public paid for the development of all this stuff. Isn't that wonderful? The problem is that although they have they have a statutory license that allows them to do certain things in certain media, that hasn't been updated, so they can't do they've got to do rights clearances if they're going to be able to put that material up, and that just seems to me to be something where we need something to help adapt this, right? It's just because it's a new medium that they need now another layer of rights clearances, but it should be available, and the prices they're being quoted are just prohibitive. And so it would just be tragic, I think, for all of this wonderful programming not to be available simply because we've got too thick a rights clearance culture. I could go on and on and on with examples, but I think I'm giving you at least a few clear examples of problems that we're trying to grapple with in this project. But under the strictest of interpretations of copyright, even making backup copies of all the copyrighted works on your hard drive, infringement. And again, this can't be right. So we need something that's a little bit more balanced. So what is it what to do? My thought is to start with some copyright principles. Try to write a small number of principles about copyright law that ordinary people could read and comprehend, and then use some examples to illustrate how they would play out in certain kinds of circumstances so that you can get an idea about how to about how to apply them. And so with comments and examples, I think that would be a good way of kind of getting this project started. But I'd like to work toward a model law over time too. It's not going to be passed anytime soon, but I think we need a good copyright law, and I'm determined to try to see if I can come up with one. So one of the sort of big things I'm dealing with is how to shrink copyright law down to a small number of components, and the paper that I have submitted for the Utah Law Review Symposium gives at least a framework about what my initial ideas about sort of cabining off the components of copyright and getting it to be a slender law again. And I think I'm not going to go through that, but the thing that I do want to talk with you about a little bit is sort of how we allocate rights. It used to be that we didn't have very broad rights. We defined the rights of copyright owners pretty narrowly. So the first copyright law applied to maps, charts, and books. And the copyright owner got the right to print, reprint, publish, and vend. Right? Those were the 4 exclusive rights that used to be part of copyright law, and actually were part of copyright law up until about 1976. So those are actually fairly narrow. What it means is those were the rights that were defined for the authors. But you didn't need to say what users could do, because there was so much that was unregulated that kind of everything that wasn't prohibited was okay. In 1976, we started defining copyright rights more broadly. And when we defined them more broadly, we also put in some rules that were exceptions for like libraries, and exceptions for education, and an exception for this and an exception for that. But we didn't really try to articulate any user rights. We just sort of said, well, okay, these are the things that, so for example, horticultural fairs have an exemption. Now, Girl Scouts didn't get one. It's kind of like who showed up. And I said, I need an exemption. It's like, well, why did you get an exemption and not these other people? So I think we need to sort of think more broadly about sort of what's the balance of rights, right? If authors are going to get broad rights, I think there's got to be some effort to try to define what are user rights also. And so that's the thing I want to chat with you about a little bit. So I have started to name kind of things that I think, if you were going to put some user rights into a copyright law, what would they look like? I think that we at least have the right to read, listen, and view copyrighted works to which we have access, right? It's not a bad idea just to say that, because then we know what we can do, among other things. I think we also have a right to intellectual privacy. So you may not know this, but some of the digital rights management technology systems that are being deployed with some copyrighted content actually contain systems that collect data about what you look at, how long you look at it, what you look at next. And if you go into some of these online services, they're making profiles of you, and sometimes they're selling data about those profiles. I think that's creepy. Okay, I think that if I'm a reader of copyrighted works, I have a right to intellectual privacy. I think that data should not either be collected, or if it is, it should be anonymized, and that its intellectual privacy is really important. I think we have a right to make limited copies for study, research, and the like. We certainly have the right to extract and reuse ideas, facts, and other kinds of unprotected subject matter in copyrighted works. We have a right to quote from existing works when we make criticism, commentary, and the like. We have a right to even draw some portions of other works in the course of making new works, whether it's a remix or whether it's a project for a class, or whether it's just You just like to play with things. Now, a few of these liberties that I've just talked about are things that you can find people saying that these are okay. But I think it's actually helpful to have a sort of a gathering of them someplace. There are also things like, should you be able to make a backup copy of things on your hard drive? Duh, I think you should, okay? It's good practice to do that. And you shouldn't just be able, the law actually gives you a right to backup software. But we need to back up other things too, including all the copyrighted articles and all the copyrighted music that might be on our hard drives. I think we should have a right to time, space, and platform shift our information. I think we should be able to tinker with our copies, right? If we want to play with it a little bit, I think we ought to be able to do that. I want to be able to even destroy my own copy of a copyrighted work if I feel like it. I want to be able to mark it up. I want to be able to interact with it, and I don't want to feel like I owe something to the copyright owner every time I start playing about things. And I also think I should have a right to do that which is necessary to enable these other rights, such as by reverse engineering if I need to be able to do that in order to engage in certain kind of activities. Little harder question, but something that I think many of you will be interested in is, should we be able to share copies, at least on a small scale, of our copies of our copies with our friends? I think many of you probably have made a mixtape for a friend before, and you probably didn't think there was anything wrong with that. You can understand how when it's kind of not just I'm making a copy for myself, but when I'm making a copy for other people, that's when copyright owners start getting really, really nervous. And so I think you could have a conversation with them about that. Because if they really trusted that actually we wouldn't abuse that, I think they might be more willing to do it. Part of the reason they get so hysterical is because they sort of feel like, well, you let one copy and then file sharing and 60 million people doing it, it's terrible. Some of these rights are now being dealt with under what copyright law calls its fair use doctrine. Part of what my project is about is trying to say, fair use is trying to do too much work. We have too many different kinds of things that fair use is being used for. Sometimes it's to allow reverse engineering for purposes of achieving interoperability. Sometimes it's for quoting something for comment, news reporting, or the like. Sometimes it's making the Google copies for archiving and for indexing purposes, and I think we need to start teasing things out so that we sort of understand what the cluster of good uses is. And I think if we can start identifying some of the clusters of good uses, that then sets off against some of the uses that that maybe haven't been named, and maybe those are the ones that we shouldn't be engaged in. So that's kind of at least an effort to address the user rights component of my project, and I'll end with a couple of thoughts about remedies. So right now, copyright law has a rule. U.S. copyright law has a rule that statutory damages can be, right? A plaintiff in a copyright lawsuit can get an award in an amount ranging from $750,000 to $150,000 per infringed work. This is a lot of money. And it doesn't have anything to do with what the actual damages are. So in the case of this young woman who got hauled before the federal court, I think it was in Minnesota, she could have bought those 24 songs for about $24 from iTunes. So $220,000 sort of seems like a lot. And one of the stories that I saw about this lawsuit and the award said that some of the jurors in that case wanted to go $150,000 per infringed work against this woman. Okay, now the other person was going for, let's do a $750. Okay, it's like, I'm sorry, that's excessive. Okay, could we just get a grip on it. So some part of what my project is about is trying to rethink why have statutory damages? How could we get some guidelines in there? Because this just doesn't make any sense, okay? So copyright law should make some sense, and I have some institutional changes that I wish to make too, but I think I'm going to end with these final thoughts. There's no realistic chance of copyright reform anytime soon. I have to tell you this. I'm going into this project knowing that it's a fool's errand. But I've noticed, as I've talked with people about this project, the dissatisfaction with the state of the law is widespread, and not just among people who think like me and who are just law professors. So I've really been excited that there's a conversation starting about copyright reform, and thanks to the Utah Law Review, there's going to be a great volume of essays to spur further work on this, and so I congratulate you and thank you for that. I'm sure Larry Lessig would have made a much more stirring case for getting you to feel like you have an investment in copyright reform, but I hope I've made at least a little contribution to that, and I'm hoping to have a set of principles or a model law by 2010. April of 2010, actually. That's the 300th birthday of the Statute of Anne, which is the first modern copyright law. And so I'm going to have a birthday party for her, and I want to have a good law. Okay? Thank you very much.
Touch on Creative Commons and your opinion about Creative Commons as it applies to copyright reform?
So I think actually one of the things that's incredibly exciting is that Larry Lessig had the imagination to think of a kind of private initiative that would be a kind of copyright reform because it provided a middle ground, right? So prior to Creative Commons, you kind of got full dress copyright, the whole 9 yards, or the public domain, and there wasn't any easy way to say, look, I'd like people to be able to make some use of this, but I'd like to be credited as the author, or I'm okay if people want to make non-commercial uses of this, but if they're going to commercialize it, I feel like they should negotiate with me about that. And I think Larry came up with an idea about how to have a lightweight regime for people who might be willing to share. And I think it was an incredibly inspired, creative idea. And I can actually imagine a copyright regime where when you go to register with the Copyright Office, you can check, I want a Creative Commons attribution license. That's all I care about. And so I think it actually could become part of a copyright reform effort too. But it certainly was his effort to try to reach out to do some copyright reform through private initiative, and I salute him for that. That being said, there are also, I'm an intellectual property professor, so I've got to quibble there and there, but I think it's a really overall very positive thing. And it created a kind of social movement also. It's not just a set of licenses. It's basically about free culture. And he's promoting a kind of free culture culture that I think is really exciting. I mean, user-generated content is a big surprise, okay, to most of the people in my field. Yeah.
As long as you're on a fool's errand, are you going to try to craft some different durations for different types of intellectual property?
I'm certainly going to play with that idea. I think that part of the challenge with this project is to try to figure out how much to feel constrained by international agreements. So the U.S. is now party to some international agreements that commit us to at least life of the author plus 50 years. That isn't to say that we can't do some things in other ways. But what kind of flexibility to think about is that's a tricky subject. So I'm happy to say, oh yeah, so much for this and so much for that. And a lot of other countries do that. So they have, so a lot of countries have 25-year terms for this class of work, 50-year terms for this class of work, life plus 50 for other classes of works. And so it's not like one can't do that, but it is the case that both the political economy problems in the United States and also we've had a culture of single terms for everything. And so it would be a pretty big change. I'm willing to think about it. Yes?
So related to the last question, it seems to me there is a fundamental empirical question underlying copyright law, which is how much time do rights have to be granted for to actually create an incentive for authors to create works? Has anyone ever looked into this?
There actually is a recent PhD thesis that suggests that 14 years, which was the original statute of Anne term, by the way. Larry calls it also the founder's copyright because when the first U.S. law was passed, it was modeled very closely on the statute of Anne. So the founder's copyright was a 14-year period. I haven't actually read the PhD thesis yet, and I don't know what other people think, but I think there is certainly considerable agreement within the economics community that the terms that we have right now are excessive. There was actually a brilliant brief submitted in the Eldred versus Ashcroft case that went before the Supreme Court challenging the Copyright Term Extension Act. 5, I think it was, or was it 7 Nobel Prize-winning economists were on that brief, in addition to a number of other very prominent people, and they said, this is nuts, okay? This is like virtually perpetual. And so it's clear that the term is out of whack by comparison with what's really needed for economic incentives. And that's the story that we've always been telling ourselves, that we're doing this in order to provide an incentive for people to create. So if we're doing too much, then the question is, how do we overcome the political economy problem to get ourselves to a term that would make more sense? I'm actually, I'm teaching a copyright reform seminar this semester, and I sort of told my class, what should we do? And the class actually said, well, I think we should have like a period, maybe 5 years, maybe 10 years, maybe 20 years, maybe 14 years. Everybody likes 14 because it's a statute of Anne. Have like a relatively short period of time where most people, if it's going to have any commercial value, that's when it's going to have it. And then, and then if you think it's going to last longer, then you have to register at the end of that term, and then you get a longer period of protection. I'm okay with that. That's actually close to what we had prior to 1976, and so some of us are kind of nostalgic for the old copyright law. Yeah.
With all the mixing and things like that that's going on today in the digital age, kind of along the lines of Professor Kogan asked, is there a way that, are you looking at the percentage of the original work that can also protect the originator, but also foster creativity if somebody is using some portion of it to make some other work that is essentially theirs originally, but they use somebody else's mix or whatever else to start something else?
Right now, what seems to be happening kind of in the marketplace here, which is not exactly an answer to your question, but sort of is. Part of what's happening is that people at the motion picture studios don't want to sue anybody who's making a highly transformative remix, but they'd like to get compensated for some things. I'm actually happy with Google making arrangement with some of them so that some of the sort of short clips that people put in. Some compensation flows back to them, but we get to make it, we get to upload it, and the rest of us get to enjoy it. So right now, that's the marketplace solution that's being accomplished, and that doesn't sound bad to me. If everything in copyright was working out that well, I would not be doing this project.
I sometimes hear the phrase copy left, and I was wondering if you could somehow define that.
Sure. This is a very clever concept. This is another innovative person in the field of digital technology. Richard Stallman, a computer scientist who worked for a long time at MIT and still has an affiliation with them, came up with the idea of copy left. What he wanted to do is to claim copyright in software, then license that software so that if anybody wanted to use the software that he wrote under this license, they had to make the source code available, they had to agree to let anybody modify the software, and then they wanted that if they made a derivative work of the software, that the terms had to essentially had to go with the digital object. Okay, so it was an effort to sort of use copyright to promote public domain values. Okay, to promote sharing. So it was in some sense inverting copyright, right? Using copyright to achieve non-proprietary goals. See what I'm saying? So that's why it's left, right? Because it's kind of trying to flip it a little bit. Instead of claiming copyright in order to make something proprietary, which is what a lot of the software developers were doing at the time that he came up with this, he sort of used copyright to open a license, but to demand that this stuff isn't in the public domain. You can't free ride on it. And so that's the twist.
Now, I have a question.
Sure.
Beyond law and economics, you tend to rely a lot on your own strong sensibility to common sense. It makes no sense. Is there an underlying norm or methodology to be able to determine how to distribute rights in some of the tougher cases? I mean, what do we draw other than your great sense of judgment?
That's a really good question, and I don't have an answer yet. I'm sort of I'm still in a very early stage of this project, so I'm sort of feeling my way along. I am working with a number of other people, and I have a feeling that in the conversations that we pursue in this arena, that we will begin to build those methods. But you know, how did copyright law get made in 1976? How did it get made in 1909? It was just a bunch of copyright lawyers getting together and saying, well, let's do this, let's do that. You know, it's like, I think I got more method than that.
Well, thank you so much for a very engaging presentation. I have just a little small bit for commenting. Thank you so much for coming in. Special thanks to Professor Samuelson for a great presentation. Thank you. That was it.